next Monday.
Request of appellant's counsel.
Yes,
Next Monday,
appellant, appeal.
16, sir?
Yes.
16.
16,
That's it. Next Monday, holiday. If you want Monday, it will be on 20th.
20th. 20th. 20th, you are
Yes.
Item number 21. Respondent counsel requested next week mirror already informed other side.
Respondent. 23. 23. 11. 18 appeals. You are for appellant. 2311.
28 to 41.
Lordship, item 53. The respondent 7. The children and husband has to be
33, sir.
respondent.
Counsel was the respondent informed the court that R7
R7.
died. You filing any memo?
Yes, I have given the details here.
While before register. You want to file a memo with the details of his legal representatives. First steps.
I give a counsel for them, let us cross check.
2311. Survey copy to the other side.
Yes.
So that they will take appropriate steps.
Serial number 38, Your Lordship. 2 weeks maybe.
38, Amma. You are for,
38. Appellant, Your Lordship.
have informed the other side. No other side.
No other side, Your Lordship.
2311.
Obliged, you.
My lord, with your lordship's permission, item number 44, my lord, if you all. In this matter, notices were ordered. I have sent notices, my lord. Out of 3 notices, only 1 has been returned. As a wait, my lord, lordship may grant some time in this matter. Item number 44, CCCA 279.
2911.
Obliged, my lord.
From the other side and let them take. I'll be the counsel.
Yes.
42 to 54.
But I not get the member of the other side counsel, but I will inform during the course of the day, you will not grant me the leave. Like I will be here on 46.
You are for appellant.
Yes.
Size 1 is there for
I could not find out the member there. 3 weeks, your lordship.
712.
59 your lordship. 39.
39. మళ్ళీ వెనక్కి వచ్చారు. 2311.
55 to 68.
50.
5 to 68. 57.
Request conference.
You are for appellant. You are not sure.
I am representing a one.
Your face reads like that. First of appellant. 2311.
69 to 75.
My lord, actually item number 57 is the Chief Buchireddy. Already informed the state is CH Janardhan sir.
ఇద్దరు తెలుసుకోండి ఎవరు రిప్రజెంట్ చేస్తారు.
Sure, my lord. 18 MACMA 18.
You are Buchireddy or on behalf of Buchireddy you are asking?
Buchireddy.
Then whose request you are making a mention? Alright, you are Buchireddy, you are not ready. You wanted time.
Kindly have this matter next week. Maybe my senior informed to
I could understand. 2311.
Conscience of this.
Tomorrow.
lordship, the MACMA matter of prevention is coming up. Maybe take on.
16, sir. 1611.
On MACMA matter.
That was argued on 19th September.
19th September, it is showing it was disposed on 19th September.
Let's go. Please. Followed in. Yes.
Daily list for pronouncement of judgment item one, Muhammad Akmal Ahmad, R.K. Chitra and K. Raghuveer Reddy.
Okay.
My apologies, I couldn't find my submission.
And there was no information from you. How can I understand the mind of the other side?
I'll explain to my lordships and
Yes.
for two reasons. One,
See, whatever may be the reason, being a senior advocate, I cannot go to the party or the client. See, when 2-3 adjournments were given, yes. Hmm.
On 21st, the last 20, last Justice M. Lakshman on this transfer, these 8 items, which were reserved for judgment for past 9 weeks, and all of them were old items. Suddenly they came up with the other judges, and since they belong to 98 and 2000, they were not even willing to grant me one day time. I was stuck up there, and the matters, 2 criminal appeals were released by Justice Anupama Chakravarti Garu and before Justice Sujana, my colleague. That is the reason. With due respect, nothing more, nothing less.
You might be knowing what happened on the previous date. I waited till 4:30. Yes.
I'm only explaining my absence, why I was not present before my lordships. And that is the paucity of time, day to day, those are being heard pursuant to a Supreme Court direction. Handicapped for time.
At the same time, you have to understand the difficulties of the court. The other day, when the matter was listed for pronouncement of judgment, I'm supposed
This
to.
is the reason I argued that matter in part in that day, despite for want of record. Whatever record I was there, I was able to assist.
Subsequently, 2 adjournments were given under the same caption.
I agree. I'm at fault. I'm not saying that.
What we shall do now?
The lordship so pleases. One adjournment for 2 weeks.
No.
I'm not going to try. Before that only I'll fight. Because day to day, even today, second item, and with great difficulty, my colleague could take pass over.
When the matter is listed under the caption for judgment,
I know,
what could I do?
My lordships may consider my difficulty also. I came a faggot. I do
File
not
an
have the
application.
record. I applied for the record since for
Then file an application.
My lordships,
File an application for reopening.
much.
I'll wait till 2:30.
My lordship, tomorrow 2:30 is difficult. My lordships. One day, my lordships.
Pass off. Shuddham.
One day, my lordships.
Next.
My lordships, may kindly pardon me.
I'm passing it over. Let me think over.
Much.
Next.
I'll assist my lordships. I'm not going to.
Today you are
pass
ready?
any lordship.
Today you are ready?
I'm ready to argue.
Then argue.
My lordships.
We'll make a note of all this.
Since my lordships have directed me to find a written submission, I'm seeking help so that I can assist better.
How can I understand when this, that was before 11th October and now we are in 9th November.
I'm telling you. My
How
lordships,
could I understand that you could not file written arguments even in the Dasara vacation?
my lordships, these are the problems.
Ivanni vaddandi. On 6th, I said you file your written arguments before the judge. Sorry, Chapan.
Wait, please.
Yes.
My lordships may take up the.
Comments from the point where you left on the other day.
Yes, my lordships, I'm coming. I was summoned to my lordships. The defendants need to have no locus to contest the suit. The simple ground that the EW2, their power of attorney, who sold land to them, admitted in his evidence that he had no power of attorney for Manchirevula village where the suitable property was situated. Hence, the compromise between the legal heirs of the plaintiffs and the legal heirs of the original owner cannot be objected by the defendants. Is my submission which I made the last time. I took my lordships to the evidence of DW2, which is of utmost importance. Then my lordships will kindly come to the judgment and decree of the trial.
Yes, yes.
My lordships, internal page 10, para 10. Are the issues which have been framed by the trial court on 4/8/1980. Subsequently to the amendment of the claim.
3 sets of issues have been framed.
Yes, ma'am. 3 sets. That is on 4/8/1983, 2/11/1988, and 22/1/1999. 22/1/1999, only a single issue was framed. I'm not on that issue because my lordships have been cautioned me saying that subsequently the earlier advocate filed an application saying that they have lost possession. So maybe the issue framed on 22/1/1999 would not come to my rescue for arguing on that aspect. So I'm only on these 5 issues. My lordships may kindly come to para number. First, take my lordships to that and then lordships. Para 14. That is where issue number 1.
Yes.
That the alleged agreement of sale dated 19/1/1976 to Germany and executed by Hyderabad Mr. Now the 11th portion that para 50 starts at para 14. The relevant para 50. Before adverting to the real point in controversy regarding the validity of otherwise of several aspects of the concept, such as the genuineness of agreement, passing of the consideration, and so-called possession on the later methods. As far as the validity of the agreement is concerned, no original document has been placed before the court for appreciation. Exhibit A22 is a copy of agreement, while Exhibit A22 is a translation. May I pass it? Exhibit A22 is not a copy of agreement. It is a certified copy of agreement filed from the other school. So this part has to be taken into consideration when my lordships are on judgment and decree. So therefore, this aspect has to be set aside, while other aspects are some. The main reason put forth by the plaintiff is that the original document is filed in some other proceedings, that is voice number 50 of 1989. That the same is not produced in the of paper, and as such the same is not produced, could not be heard. On the other, the contention of the defendants that the original agreement was taken back from the court, and in order to separate the same, it was not intentionally filed before the court. That the original is taken back or not. Certified copy of the document.
Of course, this you have argued on the other day.
My lord, I'm telling you where I have left. The other hand, in cross-examination, he states that you do not know the sale consideration paid on the agreement of sale as well. PW was the son of the original plaintiff. He admitted that he do not know that his father pleaded before the tomorrow that he has paid the total consideration. There is also a version that the order has placed tomorrow mutating his father's name was set aside in this aspect. There is a further version that he compounds the matter with GPA order of defendant in the 7 before the joint collector. We further reveals that legally here in file the suit number was 506 of 1988 in respect of the subject matter of the suit and some other. This also a definition that the author of defendants in was. He further admits that the said suit was decreed in favor of the plaintiff, saying the legal aids of Judge Jahangir Ali did not prefer any appeal against the said judge. He further admits that in case number 50 of 1980, the father of PW1 was the plaintiff and one Thai exploration was the defendant, and the said suit was filed for injunction. He admits that the suit in OS number 50 of 1980 dismissed. He said that he did not confirm whether OS number 50 of 1989, the agreement was called in NBC number 136 of 1980, and the court has informed that the original was taken back by the party to his counsel, and the same was not intentionally suppressed. Again, the same aspect of not filing the original is being visited. My submission is same. Once the certified copy of agreement exhibit 822 is filed, whether the original is produced or not is not genuine. PW1 further admits that he did not file any complaint for missing of the said company. It is also his admission that he said Thai exploration is no other than defendant in OS number 50 of 1980, examined as witness in support of father of PW1 in LGC number 136 of 1989. It is also his admission that LGC number 136 of 1989 was dismissed ultimately on merits. My lordship, this is again false. Lordship's LGC 136 of 1980 was dismissed on the ground that the civil suits are pending. My lordship should kindly note this. I have taken my lordship to that aspect of the judgment. My lordship's permits, I once again only show 2 lines of the judgment in LGC. Where
I have gone through the judgment while disposing fine arts. I have gone through the judgment in LGC while disposing fine arts. SA 610.
yes, yes. So my lordship says noted that it was not dismissed on merits, but it is really on the ground. After an elaborate discussion, they said that since civil suits are pending, we are dismissing this case. Yes. Except the evidence of PW1, none of the witnesses are examined before the court to separate the version of PW1. That late Jahangir Ali purchased the property under original of the exhibit 822, that he has paid consideration. This is the now, my lordships, I will come to para number 17. On page 15, para number 17. Few lines above para 17. All the developments are only after filing of the paper, and the same cannot be taken as a ground to believe that late either stole the property and by pledged original of exhibit 820. Contention of on behalf of the contesting defendants that the document appears to have brought appears to be probable and believable. Is only probability, no definite finding has been given by the trial court. Why it appears to be, why the contention of the defendants appears to be probable. That discussion started only on the premises that since the original has not been filed, the other contentions have been corollary to the original. And on the face of the compromise between the original owners and the plaintiffs, whether this contention of the defendants that the document does not appears to be probable or believable does not stand, does not hold water. Because there is a categorical admission before the Honorable Royal Court that the document is genuine, the consideration has been paid, and the possession was genuine. Subsequently, the possession was lost.
Yes.
Now, para 17. Exhibit A19 is the judgment of the special court in the case filed by the Elders of later against the contesting defendants here. Needless to say that late Jahangir Ali, who is no other than the father of PW, was the party in that case. The same was admitted by PW1 in his evidence. Admittedly, in the year 1993, case was dismissed, holding that the contesting defendants herein are not grabbers of the land. It's also relevant to say that verse number 506 of 1989 was filed by the defendant 8 to 18 file of this court, and the court the same was declared in respect of this time and some other land. However, it is admitted by both these artists that the said would be subject to the result of the present suit. That being so, it is independent duty of the plaintiffs herein to prove the validity of agreement relied on by them. The exhibit 824 to 826 are filed to show that the name of the father of Peter was shown in the plans from in the year 1991-92 onwards. As already stated, Supra, the alleged possession is from 1976 onwards. No piece of paper was filed before this court show that the father of PW1 was put in possession property in the year 1986. All the above documents are subsequent to the filing of the suit, and much credit shall not be given to these documents. Exhibit 826 is a document of the year 1987, 88, 1990, 90. Under this document, the name of father of PW1 was shown in the year 1987, 88. My lordships, I'll skip all this because this is with regard to possession. Lordship already it was brought to my notice. Now, the relevant portion was para 90. How the finding is given with regard to the signatures. The learned counsel on behalf of the defendants has invited the attention of the court to the signatures available in the copy of Exhibit 822 and to signature of available under Exhibit X1 to X4. Say that both the signatures are not similar. The court can compare the signatures under Section 73 of Indian Evidence Act. Within brackets, emphasis is laid on the decisions reported in 2004 ALD 84, 1998 3 ALD page 18. My lordships may pass away. Exhibit X1 to X4 are those documents which are in possession of the GPA of defendants 8 to 18, who is examined as PW2. He only says these are the documents in my possession, and I can identify the signature of late Hyder Ali. He never claimed that he has witnessed the signature of Hyder Ali at any part of time during his transactions with late Hyder Ali in his evidence. The entire evidence of DW2 is based only on Exhibit X1 to X4, coupled with the fact that after the death of late Hyder Ali, his LRs have cancelled that power of attorney, which they have granted earlier. So, the clause of DW2.
You are admitting the genuineness of exhibits X1 to X4, or you are still
disputed. Disputed. And lordships have held in a category of judgments. Comparison of signatures under Section 73 of Indian Evidence Act is highly risky. Lordship's judgment, Honorable Supreme Court, they said that the court cannot bestow upon itself the power of an expert. Now, para 20. There is no dispute about the provisions of Section 73 of Indian Evidence Act. In the present case on hand, none of the witnesses under original of Exhibit 822 are examined. Unfortunately, all of them are dead. No conceivable reason is put forth before the court for non-filing of the original. Again, the same aspect has been repeated by trial court.
You need not repeat the entire argument.
No, I'm not. I'm only on this. The finding of.
So, according to you, since Exhibit 822 is available, the non-filing of the original is not at all cannot be seen.
It's not better.
The other next aspect.
Have already. The settled proposition of law. Once the secondary evidence is exhibited, that is filed, it has been exhibited, it has been marked. Now, at the time of without
exhibited through PW1, who is not a witness to the document.
We never
and the other witnesses are not examined. How can this court believe that the document is admitted? Because it is marked.
My lord, there are two things. Marking a document is different. prove the contents. My lordships may say that the contents are not proved. That's a disparate aspect. But here it was marked. Now at this juncture, can the trial court take an objection?
Yes.
The original has
Next.
not been filed.
Yes, next.
My endeavor to draw the attention of my lordships to para 19 and 20 is only with regard to the finding under section 73.
You have argued this aspect on the other day. That is why I'm skipping it.
No,
Yes, sir. Next.
my lordships. The following, the reason given for non-acting fact should be improbable and unbelievable that exhibit X1 is the original GP executed by Hyder Ali Mirza in favor of DA. The document is of 1970. This is a registered document dated 16/4/1979. Exhibit X2 is the declaration in form number 1 under the provisions of AP Land Reforms Act. Late Hyder Ali Mirza was the declaring under this. He declared it on 7/4/1970. Exhibit X3 is the copy of the petition submitted to the Revenue Regional Officer from Land Reforms Tribunal on 2/4/1977 by late Hyder Ali Mirza. Exhibit X4 is the said to be continuation of Exhibit A. The signature in these documents under Exhibit X1 to X4 to the naked eye appears to be similar in some aspects. Now, my lordship, except Exhibit X1. So none of these documents, DW2 is a party. He has not put forth any explanation to say that is ignorant of late Hyder Ali. More so, when the LRs of late Hyder Ali are available, none of the LRs were examined by the defendants to say that this signature belongs to late Hyder Ali. Coming to the said signatures available on Exhibit A22, it is to be stated that no date of the document was mentioned in Exhibit A23. The translation, nor it is shown from the stamps are purchased or by whom the said stamps are purchased. Added to that, on comparison of the signature in Exhibit A22 and Exhibit X1 to X4, there are glaring dissimilarities even to the name. Though the comparison under Section 73 of Indian Evidence Act is not conclusive, needless to say that the other circumstances prevailing in the present case takes me to the conclusion that Exhibit A22 is not a document executed by late Hyder Ali Mirza. The non-filing of the original, non-examination of the connected persons assumes significance. The trial court itself agrees it is not conclusive, but at the same time says that they are not one and the same. They are the same. It has to be looked into from another angle. When the signatures on X1 and X4 are not proved, or any other document to show that this is the genuine signature of late Hyder Ali Mirza by a person who has seen that this is him executing or signing on some paper. This evidence of DW2
It was filed by the plaintiff. He has to prove.
No, I'm coming to.
Whatever may be, suppose if the defendants remained ex parte,
Has it
they did
been-
not examine any witness.
My lordship, has it been a finding?
All right, we'll ignore exhibits X1 to X4.
My lordship,
Yes.
sit this court like this.
In what way plaintiff,
Assuming that
sir, please answer me. In what way, how the plaintiff has proved his case? That is the question in this appeal.
Yes.
The failure of the defendants to disprove the case of plaintiff is not a point.
Yes, ma'am. That is my contention. That is my contention.
How plaintiffs have proved the case? Please argue. That's
My lordship, I have submitted. See,
yes.
one, that none of either the executed Hyder Ali Mirza or the buyer or the witnesses are alike.
See, the evidence of PW1 coupled with exhibit A22, a certified copy,
Yes.
had to be certified copy of the original exhibit Nothing is there before the court.
Coupled with the subsequent admissions of the LRs of
That you have already argued. And
they
that-
literally have to be taken into consideration.
Yes.
It was before the trial court that was ignored on the objection of defendant 8 to 18. And DW2 is best piece of evidence before this honorable court is the evidence of DW2, who admits that he has no power of attorney for Manchiriyala village. So what is the locus of the other, the contesting defendant to grab my land or claim my land, where the defendant, the LRs of later eitherly have given a statement in writing in my favor? It has to be taken into consideration by this honorable court while allowing the appeal. Now, the other aspect, para 21, is a minor discrepancy with regard to payment of consideration. That is, was taken into as a circumstance against the plaintiff. Minor discrepancy at para 21. Only with regard to discrepancy with regard to the contents of the document and the pleadings. Now, coming to the para 23 and with regard to contention, I am not troubling your lordship. Para 21 and para 23. It starts at para 21 and ends at para 23 with regard to the consideration. The aspects of discrepancies in the consideration. Almost all, with due respects to the trial court, every issue which were dealt, the finding is only non-available or conditional. Para 23, again the same aspect. Trial is not available, so we have to dispute. Oh. The lordships, para 24, issues number 1 and 2 dated 2/11/1998. According to the contesting defendant, they purchased the shoot property under estate V1 from the legal heirs of late Hyder Ali Mirza, representing through GPA. And that a suit in West number 506 of 1980 was filed, and the same was also declared in their favor. According to them, the subject matter of this suit and other land were covered through the section. This finding is absolutely false. Because the GPA holder himself admitted, which I read to your lordships on the last hearing on October. Now, my lordships, para 24 further. As far as 7 lines from the top on page 20. As far as the judgment in OS number 506 of 1989 is concerned, it is to be stated that the plaintiff's hearing of the parties to suit also. A finding is given in respect of the validity of agreement under E1. Therefore, it is not just and proper again to be appreciated the circumstances of the validity or otherwise of the agreement under. The said suit was decided by this court. Consequently, there is no necessity to probe into the matter again. As far as the finality, so my lordship, since this appeal was allowed, I need not make my submissions with regard to the judgment in OS number 506. Now, coming to para 26, this is where the issues number 1 and 2 above is held that the agreement dated 19/1/1976 not proven genuine, and there is a doubtful circumstance regarding passing of the consultation. Additional issue 1 and 2 are also decided It's plaintiff is also relevant to say that the granting of specific performance, the discretionary remedy, the person who approaches the court from such remedy shall approach with clearness. The very conduct of the parties plays an important role. Can be stated that the conduct is not bona fide, but itself is sufficient to non-suit plaintiff for such a relief. The present case on hand at one stage when deemed not something factor as parties to suit, some of the plaintiffs legal representative tried to enter into a compromise. On coming note of the same, the purchaser D8 to D18 came on. The said compromise was not accepted by the court on that ground that no original GPA was filed before the court. This is the ground on which the compromise was not allowed by the trial court, not that they did disbelieve the parties. Compromise was not. Subsequently, the things which other is brought to the notice of the court that D8 to D18 purchased the property, and the same way they were put in possession of the same. View that in that view of the matter, it is to be stated that the plaintiff did not approach the court for a relief for specific performance with clean hand. The judgments are the issue. Now, my lordships, this finding on para 26 is only on the premises that the original GPA was not filed, and D8 to D18 said that we have an agreement of sale exhibit B1. Okay. Now, my lordships may read this part of the trial court finding along with the judgment of EW2 who admitted he has no problem. And the other fact that it was cancelled on the ground of fraud. On these three grounds, the appeals have to be allowed by lordships. As far as possession is concerned, I give to lordships because some concession was made, though it is not binding on that, it is an order of the court, I have to obey it.
15th.
So please may grant me some time
No,
to file
sir.
my written submissions along with citation.
You want, you can file today or tomorrow, but judgment,
Today and tomorrow.
then 15/6, 15/11 for judgment. You have already argued at length and repeated the arguments.
Citations, I
File it,
file along with my
15/11,
master. Instead of 15, 16, 15 and a month.
16.
16.
For dismissal item 2, Play Mohan and
Right, Mr.
In the appeal by expense number 3 in appeal for March. This was fine. Parties are related, they are all brothers. Filing. File the respond number 1. The appellant was defendant number 3. The contesting defendant in the suit was respond number 3 here. But partition was filed. In partition of the scheduled property, which is a house property at Mushirabad, Hyderabad, consisting of 150 house there. Now the admitted facts are the relationship is admitted and the ownership that the property originally belonged to the father of parties is also admitted. And after the suit was filed, the Defendant number 2, contesting defendant, filed a written statement. For the first time, he propounded a will for which he was claiming right, executed by the father.
Yes.
In the normal circumstances where the relationship is admitted and even the property ownership is admitted, in a partition suit, there need not be any further conclusion to come to a conclusion that the parties are entitled for shares. Now here the defendant set up the will, exhibit B1, which is dated 13/5/2003, purportedly executed by the father, bequeathing his property to number 2. Now, on behalf of the basing on this, we take your lordship to the issue. The issue number 1 is whether the plaintiff is entitled to relief of partition of two scheduled property in 4 equal shares and allotment of 1/4 share. The issue number 2, whether the father of the plaintiff and defendant executed a registered will dated 13/5/2003 bequeathing the suit scheduled property in favor of the second. He became the absolute owner of the suit. Now, basing on these issues, para 10 of the judgment, that both the issues are taken up together under para 9. The burden of to prove the will is on D2. Plaintiff example. Now, basically, now with the setting up of the will, the burden is on the defendant number 2 to prove the will. Because once the will is proved, I will be non-suit. So I will just take your lordship to the intentions and the findings of it. Now, insofar as the proof of will is concerned, the defendant examined DW2 and himself as DW1. Before that, insofar as the court says that the issue of regarding the will has to be decided, and if for the suit, the only point to be decided is whether TFL is executed a will in favor of D2 or not. So, basing on this, the court discusses at length the evidence of PW1 and PW2. Now, PW1 is the plaintiff and PW2 is the neighbor who supported the case of the plaintiff. So, PW1 filed A1 to A2. Now, here, the court discusses at length the PW1. I'll take your lordship directly to the evidence with regard to the will is concerned. These are para 20. On the other hand, the second defendant examined himself as DW1 and he narrated the written statement in his chief. He also stated about his discharging the loan to money line credit and obtaining original papers from bank and filing the same before this court. He produced B1 to B9. B1 is the original registered will dated 13/5/2003 executed by Theophilus, son of late T. Wood. B2 is the original registered sale deed dated 24/5/62 in favor of Theophilus and the scheduled property brought for purchase, showing that he is in possession of the original title. B3 is another registered sale deed dated 28/10/2011 executed by the plaintiff D1 and D2 in favor of one Vadakapu Bhargava Kumar in respect of the property at Nellore. Here, this property, the father died in 2004. The mother died in 2010. This property at Nellore, also belonged to the father, was sold in 2011. Now, in 2011, when this property was sold, all of them the legal signed to execute the sale deed, but they were not aware of the will at all. Then thereafter, when I asked share in this particular house, he refused to give. Then I filed a suit. The suit was filed. In the written statement, for the first time they set up this bill. Till then, in fact, the other defendants or the plaintiff were never aware of that. Now, P3 is registered 2000 so and so. V4 is the proceedings of Deputy Commissioner dated 14 to D2 assessing the tax question. V5 is the original receipt for deposit and so document. Exhibit D8 is the certified copy of a judgment in AS 62 of preferred against the decree in B7 showing that such appeal was dismissed, confirming the judgment in OS 172 of 84. Now, these in the contention of it is the contention of the plaintiff that the father never executed under B1. Under A1, it is clear that the father's name of the plaintiff and the defendant was Theophilus, son of Moses, and the name of Moses was corrected as Peraya. So, from the document of the plaintiff, it is clear that Theophilus is son of Peraya and also known as Moses. So, this aspect is concerned. Now, the will which
D3 who filed this appeal was not examined, right? He did not reduce any evidence.
In fact, he was saving with the plaintiff.
And plaintiff did not file any separate appeal.
Because in a suit for party share.
Of course, I can understand. But there is no other appeal.
Now, insofar as the objection to the will is concerned, now the will, while executing the will, the name was shown as Theophilus, son of Moses. So basically, the name of the grandfather was Peraya. They say that the Peraya had converted and is changed his name to Moses. But that basically is concerned. The trial court says in A1, which is a rough scale, the name of Moses was corrected as Peraya. But rough sketch has no sanctity which is made by the party. So from the document, Theophilus is son of Peraya and also known as Moses. In fact, this aspect is concerned. It was for the but number 2 to establish that he was also known as Moses. It is clear from A and B2 that the father's name is Peraya and he is the Andhra Christian. There is no dispute about B7 suit being filed by father of the plaintiff, and then father's name is also shown as Moses. From B9 also it is clear that the father of the plaintiff were referred as Theophilus. Thus, the will deed executed relates to Theophilus, son of Moses, father of the party. PW and they are Christian, but he does not know whether his grandfather was converted Christian. Theophilus was a pensioner, but no documents are filed by plaintiff and D1 and D3 to show that his father was shown as son of Peraya and Joseph. The view of the document produced by this clear Theophilus, son of Peraya, and Theophilus son are one and the same person, and B1 will relates to him.
Is there any cross-examination about this aspect? According to the judgment, as paragraph 28, it shows there were suggestions to BW 1 and 2 only to the extent that the signatures, they are admitting the signatures. The contention is only that D2 is obtained by force.
DW2 stated that the signature which claims to be his on the will is different from what he signed in the deposition.
Is there any cross-examination about the discrepancy of the name?
As I informed your lordship last occasion that bag bundle is missing, so that depositions are not available with me.
Okay.
So here, one aspect, the admitted fact is EW1 admitted that the father had a paralytic stroke
and he was bedridden, that his right side was totally affected by paralysis. Now that aspect is concerned is an admitted fact. So my contention was that the father could not have executed a will in those conditions as this, even his mental capability was affected. Now, EW2, who is the attester of V1 will, in fact, he says that the executant was hale and healthy while executing, which fact is contrary to what DW1 himself deposed. And your lordship could see the factors to be considered to raise a suspicious circumstances for the will. Now the entire properties were given to him. Now my contention was that this person D2, the father was staying along with D. D2 was staying with the father, and he was in a position to influence the father and the mother, and mother is one of the attestors to exhibit B1 will. My humble submission that the court took a wrong perception with viewing that the evidence of DW2, which clearly establishes that he speaks more than DW1, and that fact can be easily pointed out by record, where it shows that he even describes the health of the father as hale and healthy when the defendant himself admits that he had a paralytic stroke and he was suffering from that. So my humble submission is that the will, to prove the will, the evidence of DW2, who is supposed to be an attesting witness, is not sufficient, and it is contradictory to the evidence of DW1. Because in page 18, your lordship, simply because of the statements of DW1 that his father suffered paralysis of right hand and right leg, it can be that as on the date of exhibit B1 will, he was not in a sound and disposing state of. It was not even suggested DW1 that he was not in a sound and state of mind at the time of case. No material is to show D2 have threatened theophilus. In fact, it was stated to the witness that the defendant number 2, who was staying with us, as coerced the father to execute. Even after execution of the will, and the court takes a view that after execution of the will of more than 7 years had lapsed and the property was done. In fact, as I stated, in that case, the property at Nellore was sold in 2011 only. Thereafter only I asked for a share of this property. Then when I filed, I issued a legal notice. There was no reply to the legal notice. Then when I filed the suit, the court, the defendant number 2 filed a written statement wherein he for the first time said that the will is executed by his father. My humble submission is that the court has wrongly dealt with the evidence of DW1 and 2, and the will, once it is not proved, I am entitled for a share. The appeal will be allowed as my humble prayer.
Counsel for the appellant, none afraid for the respondent. For judgment.
Item 3. Item 3, M. Papa Reddy and Mr. Sharasani.
So during this matter, my there was some last date of hearing by the time I came, matter was there is a disputed difficulty in this matter, ma'am. The official who has been looking after this matter, she is bedridden as of now. She has provided another person's number, my lord. We are trying to reach him, but he's not responding, my lord. Now, this suit was dismissed, my lord, on the ground that there was inconsistency on the ledger entry, my lord. Therefore, there are documents, madam, which are in numbers, various numbers, madam, and we do not have all the documents, madam. We'll need all the documents to argue in detail. My lord may kindly grant some time, we will get ready.
Third appellant's counsel in part 11, 16, 11, 16, 11.
Item 4, Shashikiran and Shyamnas Agarwal.
Work of such person also is confirmed.
Not for legal counsel.
I'm obliged.
Or representing.
For further hearing. Item 5. Dr. Mishra and Special Medical Govinda.
Appellant's also requested for here. It may be posted for final hearing.
Under the caption final hearing.
Admission item 6 and 7. Manik Rao and K. Siddharth Rao.
Unappeared for the appellant.
Particularly Danish and G. Dinesh Patil.
Madam, obviously, and the if the market interim order has been complained or posted finally on the immediate we are
Surrender.
named of it. By administration of the body. But immediate arguments.
Since this is not admitted, what is the substantial question for appeal? Framed. Emma? For admission, the erosional. What is the substantial question in the second appeal? There is a concurrent finding by the courts below. Are there any grounds to admit the appeal?
In fact, lordship, was engaged by the respondent part and he was painting a wall, going in the contract by lordship.
No, that cannot be decided in the second appeal. It is an appreciation of evidence that was properly done by the courts below. See, you have formulated 4.
I already filed this.
They are not substantial questions. Whether the appellant can be held liable to pay compensation without proving negligence. Can it be a substantial question in the second appeal? Heard counsel for the appellant. 7:12.
Pending on the other.
Is-
Item 5.
Number 9 requested.
5. 8.
Delay.
Name change.
You can final hearing yourself.
5 and 6.
Item 5.
చూద్దామండి. MSc MA 442. How? Counsel for 7:12.
Item 10. Madhav and Ramarao Nellutla, Y. Sudarshan Reddy.
May please, my lord, I may be permitted to appear online, my lord, in this case. I am representing Rangaram Nellutla, my lord, in this case for respondent. So it's coming for admission from since long time, my lord, in this case. A concurrent finding.
Course,
For English.
delay in filing the appeal was condoned on the previous date.
Yes, my lord.
No
It was condoned and numbered.
No representative for the appellant. As a
And
last
next week, your lordship may post it, my lord, because a declaration suit has been already filed in this case.
11.
Next week. Published. 18, madam.
16, sir. 1/6.
Okay. Much okay.
Item 11, C. Damodar Reddy.
You are representing appellant. What happened to the notice? She's made on the appellant. Seeking 2 weeks adjournment. 16, 23.
Item 12, S.M. Rafi and Khaja Mohibuddin.
My lord, presenting appellant who is no more, who filed an LR petition, set aside appointment, there was a delay. As he was a heart patient, suddenly died. Children are poor, working somewhere. Wife is permanently. They could not know the consequences. Okay. Treatment was not auto, but it is automatic. I am conscious, my lord.
Death was after filing the appeal.
Appeal was filed. They was granted by the then Honorable Chief Justice.
Have you served copy of this petition to the other side?
Served and once the stay was extended also, after that he died.
Not so many copies to use. Not so copy.
No, without having copy, it will not be numbered.
Maybe so many petitions, but they are connected. The petition is filed to condone the to bring the LRs of the appellant, sole appellant.
So correct.
You have
Fathers, sons and wife are coming on.
Right.
They're not so copy. Not.
copies even and was settlement.
There is no clear, sir.
Anyhow, the delay in filing the delay is not in filing the appeal, only to file the LR petitions. Copies even 1611. Counsel for the respondents.
My lord is pressing in execution.
Yes, because of this 2 degree long back contest or concurrent finding.
My lord, there are two judgments of Honorable Supreme Court.
Wait.
I know, gone through.
I cannot hear both the voice at one time.
I may permit it, sir.
When the execution petition is pending,
He filed after the appeal.
survey copy 1611.
Because the law is well settled by Supreme.
Will
It
hear.
was lingering.
I'll hear both of you on 1611.
There is no jurisdiction to civil court in a work property.
Item 13, Gopal Krishna Kalanidhi and Sri Raghavendra Reddy.
Gopal Krishna Kalanidhi is very sick. A short date of 1 week.
What is informed that
These papers also not.
counsel for the appellant sick and unable to argue the matter.
Item 14, Prabhakar Peri and M. Anand Kumar.
I'm for R4.
But in this matter, I am for the appellant, Millard. The R4 has to report whether R4 is alive or not. She is a 90-year-old woman. He said that he will be obtaining information and reporting it before your lordships.
R4 is alive. Bedridden.
Thank God, she is alive.
Okay, if she is alive, Millard, I have already filed an application for modification of the interim order on the basis of a succession of a judgment. I will file an additional evidence petition also, Millard. You will kindly adjourn it by a week. I will file additional evidence petition.
Week 10 as you want to.
For the respondent number 2 is allowed time for filing counter.
You want to file counter.
Yes.
Counter in what?
Respondent.
Appeal CMSA lo counter emundi. Are there any interlocutor applications? Admission కోసం. You are for appellant. You are representing R?
R2.
R2. Filed your wakalat? Huh? Mr. So-and-so informed the .311.
Item 16, Srikanahigghcourt.
ఆయన పేరు కొను.
Undertook to file color for all the respondents. It's not filed yet.
శ్రీనివాస్ వెలగపూడి.
Yes.
No wakalat so far. All right. Neho, there is no endorsement of service of the notices. Then when he has not filed the wakalat, we cannot insist him to file unless there is service. Even though on the previous date of hearing, one Mr. Srinivas Velagapudi since August, when he is not going to file wakalat, maybe for various reasons, we cannot ask him to file wakalat unless he has instructions. He cannot file. So you have to take steps for service of notices so that I can set the respondents ex parte. The difficulty is there is no service of notice, so they cannot be set ex parte. If they are set ex parte, there is a chance for them to say that without notice, they were set ex parte. Issue fresh notices to the respondents. 21/11, 2012. Both met.
Item 18, N. Bhaskar Rao and M.S. Chandresh.
We take it up next week, yeah, for the respondent.
Interlocutor item 19, S.R. Sanjeev Kumar and Chandrasen Law Officers.
Hearing for the appellant, I wanted to maybe alone, it's a small application regarding deficit court fees already been paid. Delay in representation, I3 can be heard subsequently.
I think you don't have.
Today last time the same representation.
ये नंबर थी मतलब delay in converting the representation में नोट आया मतलब delay in representing
Delay in representation and deficit court fee melon. I wanted to be allowed, 3 can be heard.
If you have no objections, I can allow the applications now itself. You want to file counter?
3 not I will file counter. Deficit court fee melon.
1 and 2 may be allowed. Deficit court fee and delay in representation.
One is to condone the delay of 376 days in filing the appeal. That is I am asking. The other IA2 is to grant stay. IA3 is injection.
3 is injection.
IA2 is
supposed to allow 1 and 2.
ఇందులో చూపించింది ఒకటి ఉంది, దీనిలో రాసింది ఒకటి ఉందండి. According to the
application, they are saying 1 month for deficit quote.
డెఫిసిట్ కోర్ట్ ఫైన్ ఇందులో చూపించారు, ఇందులోనేమో స్టే అని ఉంది. కాస్ట్ లిస్ట్. According to the governments in the in IA 2 of 19, it is for stay of proceedings, not for DCF. వేలే మారిందా?
306 CC.
ఛాన్సెస్ అయితే ఉన్నాయి. 342 ఇచ్చారా?
306.
సారీ, ఏం తీసుకోవచ్చు. So 1 of 19 for condoning the delay, you have objection. One instruction is
The appeal malad, I will.
IA 2 is to receive the court fees, DCF. Then you want to file counter in 1.
Yes.
IA 2 is on. Council. For count. 1 and 3.
Item 20, SSR Murthy and Mohammed Madhur 9 and 9.
But I am appealing to escalate. Because the content electrification is coming up for countermeasure. Whether there is delay of 376 days, delay in filing of the appeal matter. 376 days delay is was declared by the trial court. The land council has filed R9 13 petition on the trial court, and then they have carried CMA before the Honorable High Court. The CMA Honorable High Court has by dismissing given liberty to file the appeal suit malpractice. I have filed last time. I have filed some additional documents. Some document material papers I have filed.
Yes. Sure.
I have filed CMA Honorable. Page number 2220.
Additional documents and those.
CMA was disposed of. Permission is accorded accordingly. The applications have been done with liberty start for notice. That's all there.
Read that order.
This is the last document. Page number 22 starts. Number 22 is the order. It was liberty to take
When
premises.
council for. We will consider at the time of hearing the appeal from the court. The appellant here.
Posting the matter on weekly basis.
Item 21 to 24 are there. Item 25, Srikanth Hariharan and the GP for appeals.
What is the business for the trial court to file pose the matter daily when the appeal suit itself is decided? Who decide kara?
EP they have filed EP will
EP and EP is tax.
Item 25. Appeals matter.
22, 23 and TCCA and the position of payment.
Take two.
It is not so much.
No, yes. Serve him a copy. Of course, on your objection only, this it seems this petition is filed. No, serve him a copy.
Yes.
Council represent GP. (2311).
Item 26, S. Srinivas Sharma and Dinesh Jaiswal.
No representation. 112.
One.
Item 27 to 30, T. Ajay Kumar.
ఏమైందండి అజయ్ శ్రావణ్ కుమార్ ఎప్పుడు కనబడ్డాడు అది
Last time also he was.
Item numbers 27, 30, respondent. 28 to 29, appellant. Otherwise, get ready and hear you and decide on merit. Yes, I made another. ఎలాగో ఆన్ రికార్డు ఉంటాయి.
Item 31, Veera Ranganath Rao and J. Venkateswara Reddy.
One, 4, 5, 6. 4, 5 not get served by that.
ఇవాళ అనుకుంటా.
Notice 1, 2, 3 served. 5 ఒకటే unsert. So
4, 5 not served.
notice served acknowledgement కూడా put up చేశారు.
పోయింది. ఈ ఎవరే దాని మీద తెమ్మిది వచ్చినట్లు రెస్పాండెంట్ 13% ఇందులో కాదు కదా వచ్చాయి. ఎస్ సార్ ఆన్ వచ్చి బ్యాచ్ మ్యాటర్స్ లో వస్తాడు ఆయన రెస్పాండెంట్. ఎస్ how it can be shown under final hearing, sir, when some of the respondents.
First hearing was there.
For hearing.
Then last occasion, I have also argued Millard. Millard, the point involved in this Millard,
It's a
the
31.
property is an ancestral property.
Mhm.
At the time of filing suit, the plaintiff did not file the revenue record showing that it's a property of her grandfather. So,
Whatever it may be, some of the respondents are yet to be served with the notices.
ఒక్కరికే దాన్ని
1, 2, 3 and 6 served.
1-6 now represented by counsel.
2 and 6. Venkateswara Reddy
2 and
is appearing.
6.
I am appearing for 2 and 6. మిగతా వాళ్ళ family Muslim.
Sarugal.
Served. 1, 2, 3 and 6 served Millard. 5 unserved.
2, 6, 3 gala.
3 would I.
4 and
1 కూడా సర్వ్ అయిందా? You have no instructions from the other respondents.
no.
As per the endorsement, it seems 1, 2, 3 and 6 are served.
Only written statement to the I am appearing for 6, my lord.
2 and 6.
2 and 6. Main grievance is I need 4, 5. 3, 4, 5.
1 is also served.
These are also served.
So 1 and 3 need to be set ex parte. And first notice has to go to 4 and 5. R1, R3, fourteen, 12.
14.
Or finally they had
14th కూడా కాదు సార్. నేను ఆల్మోస్ట్ 10 days.
ఏ రోజు చెప్పండి?
15th. Sorry.
18, 12.
Problem.
or finally item 32. Tene Pandrangarao.
None appeared for the appellant.
Item 33, adjourned item 34. K. Uttamaga and A. Anasuya.
Hmm?
Requesting to which time?
Last time also, respondents request on the request of respondent, it seems the matter has been adjourned. That too in October. Now we are in November. Appeal by the claimant.
Claimants will be dismissed. When look at the adduced evidence by working the documents, the case of death, the FIR is filed, and exhibit P1, but investigation is completed and charge sheet was filed. We marked as exhibit A2. That the court below, without considering the same, that the evidence is not proved by the appellants, simply dismiss the OB. At the time of the death, he was working, but salary was 19,070. The incident was taken place on 11/11/2011. Was working as a contract labor in Reddy Labs. Phase 7. Number 1 to prove the manner of the accident, the petition was examined herself by PW1. And perusal of the evidence affidavit, while in view of the chief examination, would show that 11/11/2011, husband while traveling from Pragati Nagar to Bajpalli to attend his job in Doctors Reddy's Labs, his motor vehicle Honda Shine, wearing number 72. In the meantime, when he reached near Rastani building, opposite Dr. Reddy Labs, Bajpalli, the driver of the lorry, the respond number herein drove his vehicle lorry, wearing number 74. He dashed in negligent manner and dashed the motorcycle from back.
Seems the DCG decided the case as if it is a criminal case filed before him.
Yes.
Case of 304A.
Violence.
Maybe because of lack of experience. Direct DCG. Strict proof of the accident is not necessary in an accident in a motor vehicle OP. Heard the counsel for the appellant.
Item 35, Muhammad Omar Farooq and B. Madhavrao.
My lords, I beg to appear for the appellant, my lords, in this matter. Request for 4 weeks' time to file the paper book, my lords. Substituted service against R3 has already been taken out, my lords. Published. A memo has been filed, my lords.
Means one way or another you wanted adjournments.
My lords, we are only in the process of filing the paper book, my lords. Certified copies.
On 8/9, there was a request by you.
Yes, my lord.
That you will prepare a paper book.
Yes, my lord.
Again in 29/9, after almost 23 weeks, again you sought adjournment.
Yes, my lord.
Actually, to your luck, the matter was not listed in October. Still, you are in the same state. So it seems you have no interest to proceed with the argument.
No, my lords. This is the final chance, my lords.
My lord, I'm appearing for the respondent, my lord.
Hmm?
We are ready, my lord, for our argument.
Again, counsel for the appellant sought time on the
Item 36, Sri Durga Prasad and Uday Kumar Mark Shetty, Nasaruddin Ahmed Jeddi.
That part experience comes. Then the first test one for R3.
you are R for R3.
R2. Here is the R3. Here is R3. OP also is R. And the first test part is not to be next week.
You are not ready. What was the order?
Order is murder. Claim is 20 lakhs. Awarded an amount of rupees murder.
Liability is fastened against the owner or against both the owner and the insurer.
Okay. This
is against the insurance. That is a valid policy. Even though there is a valid policy, the court becomes better. The owner of the vehicle to pay the entire compensation. Even in spite of the policy is given. Not a very cover condition. Therefore, the High Court is
You have copy of the order?
taken the call.
But as per the judgment, both respondents 1 and 2. So R3 is the insurance company.
Yes, R3
The owner and who is R1?
What is the owner of the car?
No, R1 is driver, it seems.
Only the driver, R3 is one of the car. Yes, sorry.
Driver and owner were fastened with the liability.
Yes, yes. There is no policy. And here in the only the driver is the appellant.
Counsel for the appellants are time.
Item 37, yes, Satyananda Rao and G. Ravichandra Shekhar.
Respondents 1 and 2. Respondent 1 and 2 are the father and mother of the deceased. Deceased at the age of 19 years, he met with an accident and died on the spot. The insurance company, their grounds they give them 2 grounds. The third ground, the criminal article has seen that they, according to the claimant, that the deceased was traveling as pillion rider and alleged accident is due to the self-involvement by driver of the vehicle, and there is no negligence on the part of the driver. As is the company not likely to claim from this system. Already live settled that the claim rate is also entitled. And on the other hand, that the respondent number 1, owner of the vehicle, his son also is the rider of the vehicle. Respondent number. Here, respondent number 3. Respondent number 3. His son and the present petitioner's son both are riding on the bike and they met with an accident at midnight.
Both died.
Both died. So nobody knows who drives the vehicle and who is the plain rider. In that case, the case is also closed. Criminal case final report has been filed. The evidence of the PW is remained uncharged. They could not hesitate anything about the accident except the contents raised by the client petitioner. Other than the 2 issues, 3 issues, there is no other issue.
Fourth ground. No separate amount is paid for covering the pillion rider. Policy is marked.
Policies exhibit B2.
Yes.
And the 5th ground is the no driving license. But the insurance company tried to prove that the drove the vehicle and who is having a license, who is not having a license. The insurance company tried to prove that this is the pattern of insurance company to prove that the vehicle was drove the vehicle without license or with license.
What is the evidence of RW 1 and 2? RWs 1, 2, 3 were examined.
One is RW, one is the owner of the vehicle.
Father of one of the deceased.
Father of the eighth ground, Miller. What will after have seen the evidence of order is that the deceased Karthik took the vehicle and by force from his son and went on right, and his son Maharati as clear writer. He took a different similar. The crime register has taken a clear, he clear writer. So that issue has not decided regarding the effect.
Third arguments. 112.
Item 38, 39, adjourned. Item 40. Mrs. Bharadwaj Associates.
Appear for the point. It's 311.
Item 41. Rumu Chandra Shekhar and A. Ramakrishna Reddy. Yes, it's the higher one.
Who is for the appellant?
Rumu Chandra Shekhar.
No representation for the 311.
Item 42. Tum Srinivas and T. Lakshmi Kant Sharma. 42 and 43. I don't have one. I don't have one.
This here,
Last of my pass over.
but this Devan Tekla, standing council name. So many grounds are raised. Request of counsel for the appellant. 112. Both appeals.
Item 44 adjourned. Item 45. E. Venugopal Reddy and Kota Subbarao.
Okay. None appeared for the appellant.
Ramal Kumar Kedia, E. Padmavati and A. Narasimha.
Milad, I am appearing for 47 and matter, Milad. I request some time, Milad. Both the matters are connected, Milad. Both the parties are same, Milad. Not ready, Milad. Your Lordship may grant 2 weeks time.
47, no representation for appellant.
No, 47 D Padmavati. I am appearing for both the matters. I am representing, Milad. 46 and 47.
48.
D 47 and 48. Pramod Kumar Kedia and D. Padmavati.
You are appellant in both the appeals. Sir.
Both matter.
At request of appellant. 2311.
Much obliged.
Kumar Kedia, Padmavati Board appellants.
Jay Kanikaya and Mohan Krishna.
Let's see next one to finally.
Paneer 1611.
Item 50, N. Hari Prasad and J. K. Ranjit Kumar, K. Ravi Mahendra.
No representation for the appellant. 23 January.
Item 51, Akam Ishwar and I. Mahamawani.
That I represent respondent Millard Insurance Company. This is an appeal filed by the claimants Millard for enhancement of compensation.
Of course, appellant's counsel is not there.
Yes.
Item 52, EVS Ravi Kumar and Aranju Pani Kumar.
The last occasion I have taken time, I am aware. I will only brief the court of some facts today and I'll file a material slip in my order. This is the case where they have questioned the promissory note on more than one occasion and the trial court has dismissed this. My lord may see the affidavit I have filed before the honorable court. We filed OS 207 of 2012 for the first action of changes for securing the burden. The entire claim is for recovery of 10,85,000. The respondent had neither repaid the principal nor interest. When demanded, he refused to repay. Therefore, they had to issue a legal notice. Subsequent to that, they have sent a response seeking for a copy of the promissory note to be seen. Therefore, we had to issue another legal notice with a copy of the promissory note appended to it. However, Your Lords, in the written statement, in the first instance itself, the defendant successfully questioned the territorial jurisdiction of the trial court to entertain the suit in the first place. He pleaded that he never borrowed the amount, and he also went ahead to point out that there is no mention of place as to where the promissory note was executed. And also they claim that the specific requirement of mentioning a place is fundamental to any promissory note, and therefore it should contain a place of execution, and the respondent never borrowed any amount from the petition. These are the wide objections they have taken against the suit that the petitioner, that the plaintiff had filed in the trial court. My lords, the erroneous conclusions drawn by the trial court are referred to in paragraph 5 of the affidavit. And also, Your Lords, conclusively in the OS judgment, they have written to say that nothing from the suit nor the documents that are filed along with the suit were good enough to prove that there is a basic requirement of suit for recovery of money, even though there is a promissory note dated 7/12/2009. My lords may see paragraph 60 on page 27. The suit filed for recovery of money basing on the promissory note dated 7/12/2009. The initial burden lies on the plaintiff to prove his case, but as the plaintiff could not prove his case through evidence of PW1 to PW4, coupled with documents under exhibits A1 to A16. Since the plaintiff did not prove his case, the onus shifts on to the defendant to prove the defense pleaded by him. But from the evidence on record, it is clear that the plaintiff failed to discharge the onus lying on him or to disprove the case of the defendant. My lords, it is for this reason, through the affidavit, I have sought for set aside of the lower court decree and judgment here. I may be allowed to file material dispute in the matter. There is a question on the evidence, material evidence.
Heard counsel for the appellant part. He is not proceeding with the further argument. Next, 2311. 2311, Amma.
My lord, may have it December 1st.
4th, 4/12.
Order matters item 53 and 54. B. Ravikiran Rao and N. Ramappa.
Yes, ma'am. Please, Your Lordship. The respondent will go, sir. Yes.
Yes.
Respondents herein are the plaintiffs in the main suit. The subsequent appeals before Your Lordship by the appellate defendants are against the concurrent finding of the courts below. The trial court partly decreed the suit in favor of the respondent plaintiff by dismissing the counterclaim of the appellant, wherein they are granted perpetual injunction against the appellant not to disturb the possession. And the counterclaim of the appellant defendant was dismissed. Now the appellant before Your Lordship, basing on the facts instead of substantial question of law, one of the ground of the appellant is that when the respondent plaintiffs have not acquired any title over the property, even if any occupation, it has to be treated as unauthorized occupation, and thereby not entitled to any relief. In fact, basing on the exhibit A1 agreement of sale dated 3/4/1981, the respondent was put in possession of the suit scheduled property. The same is clearly specifying the exhibit A5 to A10. That is CC of Panis of MRO issued by Madnoor, wherein clearly shows that by virtue of Sada Bayanama, they came into possession, that is 1981. The respondent plaintiff came into possession of the suit scheduled property in the year 1981. Till 1981, 2004, they are in possession. That is confirmed by the lower court below through exhibit A1 to A5 to A10. So the possession acquired by the respondent over the property through legal name. And in other hand, the appellant disproved his possession and ownership over the suit scheduled property with inconsistent, invalid fees through exhibit B1, B2, B2A. That is gift copy of mutation, register sheet of the year 1977, English translation question. The gift is disallowed by the lower court below, which is inconsistent document, and there is no attestator, no transfer of the property, and no witnesses are there. And the exhibit B12 and 13 are the panis issued by the for the year 2004 and 5, 7 and 8. The two panis were issued basing on the proceedings of MRO Madnoor, obtained colluding with the revenue authorities, which are admittedly stated by the RDO. The mutation proceedings were stayed by the RDO. Subsequently, the appellant respondent filed division before the JC. That was also disallowed by the joint collector. So, as on the date of 1981 to 2003-4, the respondent appellants are, the respondent plaintiffs are in uninterrupted possession. The second ground is that respondent have not specifically taken the plea of adverse possession. In fact, the vendors of the property time to time delayed in execution of the register sale deed in favor of the respondent. That is the reason he could not register the property in the name of appellant, respondent. When the respondents are put in possession over the suit land by virtue of agreement of sale executed on 3/4/1981 by all the surviving legal heirs of deceased Bhagirathi Bai and same is mutated in the name of respondent number 1. All these facts are known to the villagers of the respondent and purchasers of the said land who are cultivating the land ever since 1981. These all facts are well known to the villagers as well as the surviving legal heirs of the appellant. None of the surviving legal heirs were raised any objection till today, and the respondent are claiming the amount under Raitu Bandhu scheme till today. And I had not joined all the legal heirs of the owners of the suit scheduled property. Admittedly, the appellant is having one younger brother Krishna and grandson of Abaji Rao Dattatri are alive. Two members of the appellant family were alive, and none of them interfered in the possession of the respondent over the property, and more particularly, the suit is declaration and perpetual injunction against the appellant who is trying to interfere in peaceful possession enjoyment of the respondent in suit scheduled property in the guise of backdoor mutation with colluding with the revenue authorities. Hence, in this regarding, the lower court, the court below given right findings that the mutation was illegal. Therefore, the RDO stayed the mutation proceedings. After mutation proceedings, on application of the respondents, again the respondent's name was re-entry in the revenue records. Third ground is that having found no valid transaction of title under Exhibit A1 agreement of sale, I have held that the respondent cannot seek declaration of title with seeking specific performance of the contract of sale, also cannot claim possession under Exhibit A1, and cannot set up free of adverse possession grossly erred in passing judgment. In fact, possession may be prima facie raise a presumption of title block. Admittedly, the owner of the property died in the year 1974, and her two sons, Abajirao Dattatri, were predeceased to her, and contended that Bhimrao, father of the appellant, cultivating the land and owner of the property, Bhagirathi Bai, executed a gift deed on 21/9/71 in favor of the appellant under the guardianship of his father. The appellant contention is that he claiming the ownership by virtue of gift deed executed by the Bhagirathi Bai on 21/9/1971. He is claiming ownership basing on the gift deed executed in the year 1971. Ever since that alleged gift deed, neither the appellant nor his father Bhimrao initiated any steps for mutation proceedings. The alleged gift was executed in the 1921. Since then, none of the family members were initiated to mutate his name in revenue record. The appellant failed to prove his possession as alleged by the appellant, and as admitted, other two legal heirs of common owner are alive who never involved in the possession of the respondents. Admittedly, two surviving legal heirs of the family were alive, but none of the member was involved and disturbed my position. The exhibit A10 and another ground is that Exhibit A10 and A11 CCs of harness for the year 2003, 2004, 5. The appellant focused on this ground only. Exhibit A10, A11 CCs of harness for the 2003, 4, 2005 and 6. Before filing the suit, the appellant is owner and pattedar of the suit scheduled property. Though there are discrepancies with regarding to possession of the respondents, and though there is a clear finding with regarding to possession and pleadings, the trial court and first appellate court proceeded as the respondents are in possession of the property. In fact, immediately after the knowledge of litigation proceedings, the respondent herein preferred appeal under 5 of ROR Act before RDO, wherein said RDO granted stay of the litigation proceedings of the MRO. Accordingly, on representation of the respondents, again the MRO entered the name of the respondents in revenue records. By challenging that order, the respondent, the appellant again preferred the appeal before RDO, that was disallowed, and again he preferred appeal revision before JC, that was also not allowed. So, by all these events are showing that the respondents are in possession since 1981 to 2003. Another ground is that the appellant filed exhibit B1 to B13 without appreciating the same in respective erroneous rejected the claim of the appellant with regarding to possession and also grant perpetual injunction in respect of the suit property. The appellant claiming his right over the suit scheduled property by virtue of gift in exhibit B1. Exhibit B1 gifted it, that is gifted in Miller. The court below gave finding on this document that it is projected as gift deed. The lower court categorically gave finding that it is projected as gift deed. Apparently, this document was prepared on ₹2 stamp paper and it is in Urdu. English translation shows that it is only a statement of Bhagirti Bai. As per the appellant, it is gift deed. Whereas in translation, it is stated that this is statement of the Bhagirti Bai who executed the gift. There is no date when the statement was given. There is no date when the statement was given. Evidently, there are no attestators to this document and contained alleged thumb impression of the Bhagirti Bai. The original signature of Deputy Tahsildar dated 25/9/1971 is on the reverse of the document. It reads as under Srimati Bhagirti Bai, wife of Baswant Rao, has presented this affidavit before me. The contents of the affidavit are true and correct. She is identified of Sri Manik, Pune of the office. So, with regarding to gift deed, there are 3 versions are there. One is statement, one is a gift, and one is a statement. So, on this inconsistent document, the lower court below concurrently finding that gift deed is disallowed. So the appellant claiming his title and possession with the inconsistent and invalid documents, that is exhibit B2, B2A, B2B, which is not valid under law. Accordingly, the court below did not take into consideration. And the cause of action taken dated 16/11/2008 taken by the appellant in counterclaim is purely created for the purpose of the false case. Admittedly, the original suit is registered on 14/7/2008. The original suit is filed on 14/7/2008 and High Court was pleased to issue urgent notice. Meanwhile, status quo orders passed on the same day till appearance of the respondent. After receiving the notice from the trial court, the respondent who is appellant herein filed his counter and WS in the IA 169 of 2008 on 28/8/2008. After receiving the notices, the appellant filed his counter and WS on 28/8/2008. After hearing both parties, by marking documents in IA number 169 of 2008 on behalf of both parties as P1 to P18 and R1 to R13. Consequently, status quo orders passed on 7/3/2009. Both parties shall maintain status quo till disposal of the main suit. At the time of filing, the trial court issued status quo orders. Subsequently, after marking the documents, the status quo orders passed till disposal of the main suit. But the appellant did not challenge the status quo orders passed by the trial court in IA. And Your Lordship, admittedly, the counterclaim was filed by the appellant after filing the WS in the suit by taking cause of action dated 16/11/2018. That is after lapse of 80 days. In such in counterclaim, the appellant has taken cause of action dated 16/11/2008 when the appellant engaged two laborers for weeding at 10 a.m. The plaintiffs came to the suit schedule property claiming ownership and threatened to dispose of him from the suit schedule property. Accordingly, counterclaim filed by him to restraining the plaintiff respondent for interfering into the possession of suit schedule property. So, Lordship, if such contention is correct, the defendant would have been taken steps against status quo orders immediately after passing the status quo orders or receiving the notices from the court. He did. Therefore, the cause of action taken by the appellant in his counterclaim purely made up for the purpose of the case. As such, there was no cause of action for his counterclaim wherein the appellant sought perpetual injunction. Hence, the plea of counterclaim itself is not acceptable. Therefore, the courts below categoric, after careful examination of the exhibits, correctly dismissed the counterclaim of the appellant. And in the other hand, the ROR appeal was filed under Section 5(5) of ROR Act by respondent before RDO in the month of July 2008. Immediately after filing the suit, he preferred the RDO appeal, wherein he got stay order. Simultaneously, the name of the respondents and entries in the revenue records. And the trial court correctly hold the exhibit B1 exposed as gift deed by giving finding quote below, correctly gave the finding on exhibit B1 that is exposed as gift deed and which is alleged to be gift deed is only affidavit as the gift deed compulsorily attested by the at least one witness. Accordingly, the document was not considered by the court below. And the exhibit B2, the copy of mutation register sheet of 1976. B2, Exhibit B2, copy of mutation register sheet of the 1976. The document contains some portion of Marathi and some portion in English script. The translation script states that Bhagirati Bai died and she blessed with 3 sons, and the real right holders Lingu Bai, wife of Dattatri, who died, and Baswant Rao, son of Avaji Rao, who died, and Bhim Rao have equal rights, are entitled to mutation. In Exhibit B2 stated that all the surviving legal heirs are entitled to the get property. And Exhibit B2A, English translation portion of B2, Milord. The translation reads as Lingu Bai, wife of Dattatri, who died, and Baswant Rao, son of Avaji Rao, died, and Bhim Rao is shareholders. So according to B2A, Lingu Bai, Baswant Rao, and Bhim Rao are the legal heirs of the Bhagirati Bai. In fact, these 3 persons were executed Sada Bainama in favor of respondents in the year 1981. As admitted by the Exhibit B2, the names narrated in the Exhibit B2 were executors of the sale deed in favor of respondent. And Exhibit B2B, Marathi script on Exhibit B2. The portion of Marathi script mentions that according to registered will, which has been certified by the Deputy Tahsildar on 25/9/1971, the patta gave to survey numbers to her grandson. This portion is dated 9/5/1976. The Deputy Tahsildar attested on the Exhibit B2, which is Marathi script of B2. B2 is the gift deed. In that document, stated that the pattadar gave to survey numbers to her grandsons. The portion is dated 9/5/1976. One side, the attestation was made by the Deputy Tahsildar on statement on 25/9/1971, and the portion is dated 9/5/1976. The alleged document was executed in the 1971, and the attestation of the Deputy Tahsildar in the year 1976. If considering that 1976 will, you would have mutated his position, his names in the year 1976 itself. And Exhibit B3, Patta passbook issued basing on the MRO proceedings in favor of the appellant, which are admittedly stayed by the RDO Bodhan. Exhibit B12 and B13 are the bondis issued for the year 2004, 5, 7, 8 in favor of the appellant. The 2 bondis issued by MRO Madhur, which are admittedly stayed by the RDO. Subsequently, the names were removed by the MRO. Hence, the ground taken by the appellant is not acceptable. And the appellant has taken a substantial question of law for second appeal. One is that whether the finding given by the trial court and first appellate court are perverse and contrary to the evidence on record. This question is purely basing on the fact, not on substantial question of law. In fact, basing on the evidence of PW1, PW3 and DW1, the court below gives truthful findings regarding the position of the respondent over the food schedule property basing on the exhibits. Miller, The DW1 categorically stated in chief examination the DW1 appellant is categorically stated in chief examination that the said Bhimrao, who is the father of the appellant, was own son of Bhagirati Bai and he is no more and died in the year 1982. His father was died in the year 1982 and also given an affidavit before Deputy Tahsildar Madnur for mutation of the suit schedule property. In fact, the exhibit B2 gift to deed was executed by the Bhagirati Bai in favor of appellant when he was minor under the guardianship of his father. His father was died in the year 1982. While his lifetime, he gave affidavit before Deputy Tahsildar Madnur for mutation of the suit schedule land in my favor. The DW1 categorically stated that my father has given an affidavit for mutation proceedings in the year 1982. The said gift deed was executed on ₹2 stamp paper bearing number so and so on 21/9/1971. The back of stamp, the Deputy Tahsildar Madhur made endorsement of the statement of Bhagirati Bai dated 25/9/1971. So the document was executed, alleged to be executed in the year 1977. Till 2004, he kept silent, and after that, he created false counterclaim. And while cross-examination, the DW1 appellant hearing categorically stated that while cross-examination, DW1 categorically stated that I first came to know about Exhibit B2 in the year 1987-88. He admitted that about gift deed I came into my knowledge in the year 1987-88. But he kept calm till 2005. And another substantial question of law raised by the appellant herein, whether a counterclaim for perpetual injunction can be rejected by granting the relief of perpetual injunction in favor of the respondent plaintiff when the documentary evidence shows their interrupted possession and when the plaintiff failed to establish their possession over the suit land. There is no interrupted possession, my lord. In the year 2005, the name of the appellant mutated in the revenue records without following ROR rules, without issuing notice to the respondents. The mutation was done. Subsequently, after knowledge of this mutation proceedings, we filed RDO appeal and wherein we got stayed. In the circumstances, it is very clearly reveals that the respondents are in possession ever since a purchase and mere backdoor entries of the name of the appellant in revenue records for some time, that is 2 years period only, without following ROR rules is not acceptable. And on that aspect, the trial court and first appellate court gave correct findings by declining the possession of the appellant and accordingly dismissed the counterclaim filed by the appellant by confirming the possession of the respondents. Considering all the facts, and the appellant court granted perpetual injunction orders in favor of the respondent, restraining the appellant. In fact, admittedly, the suit schedule property belongs to the Baswantrao, husband of the Bhagirti Bai. After the death of Baswantrao, the property was mutated in the name of the Bhagirti Bai, who is wife. In that aspect also, the Bhagirti Bai is not having any right over the property. In fact, the name of the appellant entered in the revenue records based on invalid document, that too without following the rules of ROR, and same was not been considered by the court below. In this regard, the appellant failed to prove their position, as such the courts below concurrently finding by disproving their position and confirming the position of respondents. Another question of law is that whether the trial court and the first appellate court are justified in granting perpetual injunction without giving any specific finding with regarding to the position of respondents as on the date of filing of the suit. This is main important question. This is also basing on facts. In this regard of the position, the court below gave finding that the cumulative scrutiny of the documents filed by both the parties, the name of the plaintiff was shown in possession column against the suit land from 1985-86 to 2003-4, and he was also issued patta passbook and revenue records in respect of suit land, and they also supporting the position of the plaintiff over the suit land. In view of the facts, the plaintiff established their position over the suit land from 85-86 to 2003-2004 under Exhibit A5 to A10, coupled with Exhibit A16 to A18. A16 and A16 patta passbooks. Further stay was granted in ROR appeal filed by the plaintiff against the defendant not to dispose of the land. It is also observed that under what proceedings the name of defendant was entered in the Panis under Exhibit A11, 12, 13, 12 and 13. The mode of recording the name of defendant as pattadar and possessor in revenue records against the suit land was not filed by the defendant. To show how he acquired the suit land in his name. The defendant was also silent why he did not choose to file application before revenue authorities after he attained majority for mutation basing on alleged gift dated 1971. In view of the above facts and circumstances, the trial court rightly held the defendant failed to prove his continuous possession over the suit land and dismissed the counterclaim. On the other hand, the plaintiffs have proved his possession over the suit land from 85-86 to 2004, coupled with 16-18. The agreement of sale under Exhibit A1 dated 3/4/1981 also shown the vendors of the plaintiff have delivered the possession of the suit land to the plaintiff having received entire sale consideration. The Exhibit A1 sale deed categorically stated that the entire sale consideration was paid by the vendee and the possession of the suit schedule property delivered to the respondents. Therefore, trial court rightly granted permanent injunction in favor of the plaintiff, restraining the defendants. And another question of law is raised by the appellant is that whether the relief of perpetual injunction can be granted against the legal heir of original owner of the property in the absence of title acquired by the respondent pursuant to alleged agreement sale deed. The matter of fact is that by virtue of agreement of sale dated 1981, the respondent was put in possession of the suit scheduled property. Ever since they are in possession and the entire sale consideration was paid and the possession was delivered in favor of the, into respondent.
Repeat here then. Yes.
And another thing is that no legally are claiming the property in the capacity of successors except the appellant claiming through alleged incomplete gift deed, which is created by him to grab the property. Relief of injunction can be granted except against the two owners. Admittedly, the title claimed by the appellant dependent was not accepted by the trial court. And another question of law is this: whether the suit for declaration of title and perpetual injunction based on the agreement of sale maintainable without seeking the relief of suit of specific performance. The suit for injunction can be filed against the persons of disturbing possession, for which need not ask for any specific performance against the third parties who is disturbing the possession. In fact, admittedly, the appellant defendant has no title over the property. He is claiming his ownership and possession by virtue of alleged gift deed, which was disproved by him before trial court. The same is confirmed by the courts below. So, no title is in favor of the appellant and ownership claimed by the appellant to a possession for a period of 2 years and revenue records is not considered by the court below. Whether the unregistered agreement of sale which has not validly executed can be relied upon with regarding to delivery of the possession by granting the relief in the suit. Admittedly, through Exhibit A1, agreement of sale dated 3/4/1981, the entire sale consideration has been paid and possession was delivered. So there is no part performance as the entire sale consideration was paid by the vendee and possession has delivered to the respondent. Evidently, the respondent proved their possession with confirmed by the court below. So therefore, the appeal filed by the appellant defendant is not maintainable. Therefore, the court judgment of court below may be.
Yes.
Short reply in favor of my contention. I am having some citations.
But Your Lordship may kindly see the main ground which was raised by the appellate was page 40. Your Lordship may kindly see. There are practically the result is suit of the plaintiff is decreed partly with cast. The prayer for plaintiffs 1 and 2 declare that they are absolute owners of the suit property declined, but their claim with regard to title is declined. And then, my lord, defendant is hereby restrained by way of next, my lord, defendant hereby restrained by way of permanent injunction from interfering with the peaceful possession and enjoyment of the plaintiffs 1 and 2 over the suit scheduled property. But Your Lordship may kindly see, but on the other day, the main point which I raised before Your Lordship and at the time of admission, which I convinced Your Lordship is, section 38 of specific effect clearly says that as on the date of filing of the suit, they should be in possession of the property for grant of perpetuity. That is the crux of the issue. My learned friend says he is in possession up to 2003 to 2005. And the my lord, and my counterclaim is basing on the possession over the property as on the date of filing my counterclaim. My learned friend, my lord, in so many terms admitted that he was in possession from 2003, 2005, 2004-5. But suit was filed in the year 2008. But that is the law laid down by this Honorable Court. My lord, I will provide 4 judgments of the Honorable Apex Court. But clearly said that for grant of here, my lord, declaration of title is not there, and there is no finding by both the courts, trial court as well as the appellate court, that as on the date of filing of the suit, he is in possession of the property. That is important. Whereas my own documents, my lord, I filed exhibits. My lord, your lordship may kindly see the exhibits also. My lord, exhibits B1 to B13. B13 clearly says, my lord, Pahani issued 6/8/2008. And he himself filed, my lord, exhibit A12, Pahani, for the year 2006-2007, even before 1 year before filing of the suit, wherein also, my lord, I am in possession of the property. I'll read that. Exhibit A11 and A12 are the certified copies, Pahanis for the year 2005, 6 and 7, respectively. And these documents show the defendant to be the owner and patedar of this property. But their own document shows that I am in possession, owner and patedar of this property. And the main contention was, my lord, that they failed to prove possession. My lord, here declaration of title is not there, and correction of entries in the revenue records was also not granted. Any relief was not granted except injunction. For granting injunction, my humble submission to your lordship is the law is that they should give finding, not that as on the date of filing of the suit, he should be in possession. He admittedly, my lord, is not in possession of the property, whereas in the counterclaim, I said I am in possession of the property. Their own documents, my documents clearly shows that I am in possession of the property. And then next, my lord, your lordship may kindly see, even the appellate court also, but page 19 says, exhibit A11, A12 are the Pahanis for the year 2005-6, 2006-7, show the name of the defendant in patedar and possession column against the suit land. But there is one more provision in the ROR Act, section 5A. But that 5A says, well, if they have purchased the property in the year 81, they could have availed the revenue. 89, it came into operation, they can have gone for regularization of the sale deed. That they have not gone. They have not filed suit. And they are hopping upon only agreement of sale, leaving about my gift deed, which is prior to that. And this, they, according to them, 81 it was sold through agreement of sale. They did not take any steps for regularization, but that opportunity was there. And specific performance of agreement of sale by filing the suit that they have not availed. And continuously their names were not there in the revenue records. And you lordship may kindly see the original copy of mutation register 76 also shows that my name. But all these factors are there. I am not a stranger. I am the grandson of Bhagirathi Bai. Bhagirathi Bai name continued. They could have taken steps for mutation of their names in the revenue records as per provisions of ROR Act 1971, or by filing a suit for getting it for obtaining the valid sale deed, registered sale deed from the LRs or whoever he may be. They may be. But that they have not done. And that's the reason trial court rightly declined to grant title with regard to ownership, but granted injunction. While granting the injunction, of course, suppose if ownership is declared, then automatically possession follows. One can understand. That is also there, not there. A person claiming to be the purchaser through agreement of sale says that he is in possession, but either on the date of filing of the suit, he is not in possession. He has not availed the remedy under ROR Act 1971, and he has not filed the suit. He has not acquired the title over the property. Whereas in 76 itself, the mutation register shows my name, and subsequent Pahanis also shows that my name and the Bhagirathi Bai's name with regard to possession over the property. That's the reason my counterclaim is liable to be allowed, and their injunction, since both the courts, that's the important aspect. Both the courts failed to give finding. But my land friend failed to show that with regard to the finding that both the courts that to show that these respondents are in possession of the property as on the date of filing of the suit. For that, I am citing. Last time I submitted, but for your lordship's kind convenience, these four citations with the paragraphs language. That is the important point. Which
both appeals are reserved for judgment.
My lord, agreed.
Next.
Obliged, my lord.
For continuation, item 55, Bhagatlal Mandane and Namas Victor, the lawyers.
Password.
Item 56, Kota Subbarao and C.H. Janardhan Reddy.
My lord, respondent counsel requested next week, my lord. Item number C.H. Janardhan, my lord.
Source of respondent. 2311.
Obliged, my lord, obliged.
Item 57, and item 58. Kalapur Srinivas Rao and Krishna Kishore Kanguri.
Apologies. Yes, I was absent on last decision. It's a case of injuries. Client is RS 9 lakhs. Awarded amount is 3 lakhs 89,000 with 7.5% interest.
Yes.
To prove the rash and negligent driving, injured himself, examined, and to prove the gravity of injuries, PW2 and PW3 are examined. On the other hand, the respondent did not examine any witness except RW1, who is the driver of the vehicle. Though the several grounds were raised by the appellants, essentially the ground of appeal is there is a contributory negligence on the part of the respondent injured. But to prove the same, they did not examine any witness. RW1 was examined. He himself admitted his guilt before the competent criminal court and paid fine. Therefore, there is no evidence to substantiate the plea of the contributory negligence on the part of the injured. Therefore, there is nothing to interfere by this court.
Where is the proof that he admitted the guilt and paid fine? Is there any cross-examination? Have you filed copy of the judgment?
Your Lordship, may kindly see the order of the trial court, page number 3, while discussing the issue number 1, that is rash and negligent driving. Para 8, the charge sheet shows that the driver of the bus was responsible for the accident and he was charge sheeted for the offence under 338 of IPC. RW1 examined to show that the accident occurred due to negligence of injured. Exhibit A4 shows that RW1 admitted guilt and he was let off with fine. In this backdrop, there is no evidence on the part of the apparent insurance company to substantiate that there is a contributory negligence. Therefore, Your Lordship. And the injured is 20 years old. According to him, the evocation is cultivation, but it was not taken. He was
Also, afternoon judgment. సాయంత్రం చెప్తాను.
obliged.
మిగతా లోక తర్వాత.
Your Lordship, the reserved.
Today itself I will dispose of
Sure.
in the afternoon session. After second. Shurupachari. 72 hours. You need not wait. I'll allow the appeal, but in the afternoon, write a separate order. I'll declare the order. The state and bracket.
submitted arguments during the law. I don't want to read the entire plain written statement. One thing is, pleadings cannot be said to, contents of pleadings cannot be taken into consideration without there being any evidence. I think that the Supreme Court will not differ from my submission. The contents of written statement itself cannot be taken as a proof. With regard to the contents mentioned there, please taken in the written statement, cannot be said to be accepted without there being any evidence. Second thing is, if plaintiff or witnesses from whatever side comes into witness box and they were not cross-examined, can they challenge or make, they have got right to make any comment on the chief evidence which is undisturbed? That is the second ground on which I want. Third thing is, the document which has not been placed in the, either along with the written statement, it was not referred to, nor it was filed. In this appeal also, the trial court, though rejected, saying that this so-called adoption deed was since basing upon the judgment of the apex court as well as disarm court. That's the Justice Subhash Reddy's judgment. Saying that once document is not referred in the pleadings cannot be received in evidence. At least if the document has not been filed in the appeal, along with 41-27, the trial court rejected. Please consider this to receive in evidence. So, keeping in view of this principle, now I want to submit what is the basis for the argument that plaintiff stated like this, written statement like this, and no burden is casted on the plaintiff. His entire ground was plaintiff failed to prove that the defendant number one obtained as a manager or karta of joint family or existing the HUF with D1 and D2, D3. But his argument, entire argument, the some court is that only. Now, who pleaded, and my contents in the plaint as well as in the evidences, they constitute HF and he being a karta.
Where is the proof that he being karta of HUF borrowed, received the money? Where is the evidence?
No. I have stated in my plate, I have stated in my evidence. It is undisturbed. Can I see the evidence? Okay.
So you mean to say, since there is no cross-examination, the entire evidence of the plaintiff will be.
What says? And that just that the decision. Section 114G, if any I'm going to see that how far the Supreme Court went. Supreme Court says cross-examination also due. And the defendants 2 and 3 here, they did not choose the evidence. Defendant failing to appear as a witness in the substances is defense. It can be presumed, that is,
plea in the written statement are not established, suit can be decreed on the basis of evidence addressed by plaintiff. Whereas, you also may see next, that is, next page. Here D2 and D3, they are claiming because they are now contesting this appeal. They say that no, we are separate family. We are not joined along with the father of defendant number 1. And suit has been collectively filed only to extract money from D2 and D3. That is the statement. No, they did not choose to enter into witness false. Whether their written statement can be taken as the gospel truth? No. So, my humble submission is the wrong court. And the next page, last page, has been clearly written that their written statement, contents of their plea is not. So, this is one thing. Then, coming to the factor with regard to non-cross examination. Look into the decision of our High Court. This is 2011 to ALD 536. Para 63, last but one page. I highlighted it. Once a fact is testified by a witness and the same is not challenged in the cross-examination of such witness, it can be safely be said that such a fact is admitted. Similarly is the decision, of course I had not, but let me take note of it. 1971, yes, 1971, 1 ALT, page 5. That's it, just I found on and in para 23 of the judgment, relying upon 1960 Calcutta division bench held similarly. What is the effect of non-cross examination of in detail in para 23 of the judgment? Well, because this is latest one, so this is the presumption. They did not choose to cross-examine the PWs 1, 2, 3, 4. Then what is the proof? That is deemed to have been admitted. Admitted facts need not be proved. Other evidence, what is necessary? Everything the other side argues that this is the plea, I have taken the written statement, so burden lies on the plaintiff. You did not choose to examine yourself. You did not choose to cross-examine. Still you say that plaintiff failed to prove. Why evidence has to be let in when the facts deposed on oath has not been controverted? Then, coming to another this 2009 ALD, 4 ALD, page 689 division D, para 41. This I want to rely upon, para 41. That's what, that's last one thing. Pleadings and proof. Some court will decide that proper foundation has to be laid in the pleadings by setting out the material facts, and later the pleadings have to be proved by adducing requisite evidence. Specific allegations have to be made and proved. mere pleading cannot be taken as evidence unless the party adduces oral and documentary evidence and the court accepts the same, and on analyzing such evidence holds that the facts is proved. Therefore, mere allegation by one party cannot be taken as corroborative evidence. Therefore, the pleadings of one party cannot be treated as corroborative evidence of the pleadings of other party, though they make similar pleadings. So that's why I said that mere reading the written statement saying that we have contended, that contention cannot be looked into in the absence of oral evidence. And more specifically, when you did not choose to enter into official work, according to Supreme Court, the contents of the written statement deemed to have not been proved. So that cannot be taken as evidence at all. And burden cannot be pleaded because you pleaded, unless you dispute it in cross-examination. If you dispute it, certainly the other side would have been right, justified, that I did not choose to produce corroborative evidence. Corroborative is required only in support of the trial court did not choose to look into all this. None of the decisions referred have been considered by the trial court. I don't want to make any, except saying that the judgment is perverse so far as then another important aspect is that though they plead adoption by deed, they are not saying that there is no document evidence. They pleaded that was not filed along with you also may see that list of documents annexed to the written statement. No. Even they did not choose to rely upon the document in the written statement. 7 Rule 14. There is no reference with regard to the document, date of document or anything. Then it amounts to that document, since that it was not marked. They did not choose to even try before the Supreme Court also to get it marked under 41 Rule 27. Then it amounts to suppression of material document before the Supreme Court.
Where is the averment by PW1 in his chief affidavit that the amount was received by D1 on behalf of the entire family?
Entire family, as a head of.
Of course, that is there.
What is that?
The amount was given to D1 alone. Eldest member of the family.
The amount was paid to D1, but in what capacity? You have to see that. What is stated? Very first para in para 2, I submit that the defendants are closely related to us. Keeping in view of the relationship, the first defendant, being the eldest male member of the defendant's family, informed us that if we, the plaintiff, deposits money with him, he will pay interest more than the bank rate at the rate of 30%. Keeping in view of the relation and the offer made by the defendant, being the eldest member of the defendant's family, I am not in any way saying no other person is there, being the eldest member of the family. That word HF is not necessary unless.
Right.
So my submission is, this is not in this book. So my humble submission is that document is not said to have been, is not sought to be produced before the Supreme Court, even at this juncture. It amounts to suppression of material document before the. If a document, material document is suppressed, material fact is suppressed, it amounts to playing fraud on the court. That is what also has been held. A number of decisions on this aspect on court Delaware. 2009 or ALD. As I say, 2009 4 ALD place 79 Supreme Court. It suddenly established what the facts separate from the court, it amounts to playing fraud. Now, the other side, yes, with regard to one more decision, 1999, 3 Supreme Court cases, case 573. Para 17. Anything larger, that is, where a party to the suit does not appear in the witness box and states his own case on oath and does not offer himself to be cross-examined by the other side. A presumption would arise, but the case set up by him is not correct. This is para 17 plus. Para 17.
Yes.
Now, keeping in view of this member solution, the trial court did not to consider it. Trial court assumed and that the defendant is 2 and 3 are different from defendant of one family and did not choose to grant cause a decrease so far as the other check is concerned. Now, coming to the facts with regard to, I claimed my statement on oath is that they have received 10 lakhs rupees by way of checks. The trial court only granted decrease to the extent of 7 lakhs. What for the other portion of the checks that claim has not been granted? Lordship may see that the grounds has given, it's only assumption. That's not proof. What is the proof required for that? When I gave evidence in the past, parties came into witness box and gave evidence. All the brothers, they gave. It is not that PWL representing his brothers, he gave only. All the plaintiffs, they came and deposed. Then why their evidence should not be believed? Number 7, the trial court did not just give any reason for that. And that's why this appeal is only filed to the extent of not the entire claim by the plaintiff, to the extent of the claim which was not granted. There's no either counterclaim or any cross appeal before this lordship. So far as the entire decree is concerned, this appeal is only limited to the extent of non-granting of this other portion of the decree. The trial court only said that I prove only 7,50,000 is enough. Rest of the portion lordship, this appeal is over. It's not for the entire claim. So I mean, and my humble submission is this entire thing which has been decided by the trial courts is.
I will land counsel for the appellant. In reply, judgment is reserved.
I'm not making any reply here. I've already furnished a paper book of what I have filed before this court. The adoption deed, the deposition in chief and cross of DWN is there on the card. I also filed the adoption deed. And pleadings and proof are not there was my plea basically. Even as Karta of the family has not received.
Next.
Vyavaharika debt, that even as a Karta.
Right, sir. Is it reserved?
It amounts to, there is no need of.
Item number
that
58.
HDF the word
Name Japanese. Item 58.
Item number 58, Kalapur Srinivasa and Krishna Kishore Koguri.
Any date is fixed.
Reserved.
No date. Process reserved. I am obliged.
Appeal is dismissed. Date appeal is dismissed. Your appeal is dismissed, sir. 71.
Item 70.
CMA
Yes,
dismissed.
Krishna Reddy and Surendra Reddy.
Appeal is allowed. Huh? Next to be allowed.
Item 72, T. Viswarupachari and Anantula Ravinder.
Allowed. Japan. 74. Missed. 75 date.